Hi, good afternoon, everybody. Gabe, City of Oxnard resident. I'm doing a really quick live video to talk about the ruling that came out yesterday from the Ventura County Superior Court in regards to a lawsuit that Starr had brought forward against the City of Oxnard about their what's called an infrastructure use fee within our enterprise funds. So, real quickly, some of you may recognize this. This is a bill that comes in every single month, and many of us pay it every single month. Most of the time, I'm included in that. So this is something that was a really hot topic a few years ago with the water rates, or wastewater rates, I should say, as well as the infrastructure use fee, which we're going to be talking about today. Hey, Paul, good to see you. And I just want to say that there's so much that goes into the infrastructure use fee and the water rates and all of this stuff. It's really thick. I had to read the court ruling twice, once yesterday and then once again today with a really fine-tooth comb to really understand what's going on. And at the end of this video, what I'm going to do for everybody is I'm acting like I'm a YouTube star now. Hey, you got a special code if you use /Gabe Teran. No, I actually went through the entire ruling and I highlighted the key points. And there was a lot of, there were some legal terms using that as well. And I added comments that you can click on, and it gives you a definition of what the legal terms mean and what it's trying to say, and try and explain some of that. So the idea is I'm going to post the ruling as a link at the end of this video that you can see in the comments. You can go through, read it, read just the highlights, read more in depth if you want, but hopefully it can give you a really good understanding of what the judge actually said versus what's been reported so far. So let's get into it. So the idea behind the lawsuit was around there's three funds that we have in the city of Oxnard that are their own budgets, all right? We have water, we have wastewater or sewer, and trash or environmental resources, solid waste, whatever you want to call it. Those three funds are three different programs and their own budgets, and they're all supposed to be self-sustainable. And because they are what's called an enterprise fund, those are charged to us on the bill we get every single month, and you'll see all three of them listed there. Mine says water, sewer, and residential refuse, right? And it tells you how much you're being charged, okay? So the cost of charging those fees, or I should say those rates, are supposed to be the cost of what it costs to provide the service, all right? So if I'm paying $31.88 a month for my trash, well, that's about what it costs per person, or in my case, for my parcel, to provide trash service to my family, to me, right? And that, if you can imagine, every household pays that. That's supposed to sustain the cost of trash service. And that's just one budget. There's three, remember, there's water, sewer, and trash. So that being said, there was something that was being embedded in those rates that we get every month that was called an IUF, an infrastructure use fee. And the way the city was justifying that was that these fees are, in addition to the rates, the cost of doing business for these three funds. So what they were doing was they would charge that fee, and there's an ordinance that allows the revenue from those fees every single month to be transferred to another budget. In the past, they were transferred to the general fund and were used for things like public safety, and then they were also transferred to the streets fund, which is a totally different budget than the general fund, all right? Keep that in mind. So the idea behind this was that public safety, for example, let's say that a fire hydrant busts, right? And there's water just flowing everywhere. Well, police have to block off the street to block that, and then folks have to come in and fix it from Public Works, right? Well, who pays for the cost of police? Well, we do, right? And that's just an example. I'm not saying that's what they did, but it's an example of how they were looking at how can we recover some of the cost that is incurred on other parts of our city's budget to these different enterprise funds. So when you look at another example of the streets, right? The trash truck driving down the street it weighs a ton, and through it driving through the street, it's going to do wear and tear on the alleys and on the surface streets. So the cost of that, that doesn't necessarily come out of the rates that you pay every month for your trash. That rate you pay is meant to cover the cost of providing trash service. So the idea behind that use fee is that, like, okay, we can take it out of this extra amount that's being paid to put in the streets fund to help maintain the streets. I hope you're making that connection. Again, these are all examples. All right. So let's look back on this now. The lawsuit that was brought forward by Aaron Starr against the city was around the infrastructure use fee, because there are actually propositions that were passed in the state of California that amended California Constitution. Prop 218 is mentioned in the lawsuit, that state some things about fees, and these are meant to control that that any city can't just like randomly charge fees instead of raising or passing new laws for taxes, right? So it was a way to keep cities from like circumventing propositions that prevented them from just implementing taxes without people voting on it. So what we want to look at here, the infrastructure use fee, there's a couple things that go into it. Number one, they have to show that you can't charge the infrastructure use fee in excess of what it actually costs for what the fee is going to cover. So the example I gave you of the trash truck driving on the streets, well, if you were to estimate that, let's say that it's 30 cents per person per month to maintain the streets, a little bit more because of the damage that are done by the trash trucks. All right, well, let's add that onto the fee, and you can show your work on that, right? So that's one, that it can't be excessive. It also can't be used for anything other than what the fee says it's being charged for. So they can't charge it as a fee for maintaining streets because of the wear and tear from trash trucks, and then use that fee to let's say to fix like the city hall building. Like, you can't do that. It has to be used for what you said you're going to use it for. All right. And then the other part of it is that it can't be used for general services like police, fire, or the library, things that taxpayers pay for anyways. Now, the example I used earlier, let's use fire, for example. Let's say that there's a number of calls for service throughout the year to the environmental resources, to their MRF facility, where you take all your stuff on Del Norte. Let's say that they have to go there every so often to provide services. There's calls for service for like fire or hazardous materials or whatever it is. Well, there's a cost for fire going to do that, right? So that being provided, that's kind of a loose way to look at it, but you can see how that connection is trying to, or could be made there, where, well, our fire is providing extra services to the environmental resources department because they have to go there so often. So we should be charging a fee to cover that. And that's an example, all right? I'm not saying that's actually what happened. But you can't just say, like, we're going to charge a fee and we're going to apply it to fire to help cover fire costs, like across the whole city. No, because our taxes already pay for all that fire, all right? So that's the difference there, where you have to be very clear and specific. If you're going to charge a fee, this is why we're charging it, this is how much we're charging, and being able to justify that. So that's what was at issue in the lawsuit. And so looking at the verdict of the lawsuit, or the ruling that came out yesterday, again, I'm going to post a link to the judge's actual ruling, but it looks like the city didn't actually provide much evidence or testimony to show why they were charging what they were charging. And when you read through the ruling, you will see that they had an expert witness who was actually the principal consultant from 2012 who developed the formula for how they came up with their IUF for their fee. However, that person's deposition or their testimony was not allowed in court. I'm not sure why. I haven't seen court transcripts. All I have is the ruling. All it says is that Aaron Starr objected to that person's deposition or their evidence, and the court agreed and said that that person's evidence or testimony wouldn't be allowed to be admitted into evidence. Now, the report that they made back in 2012 was admitted, but they do state we only considered this on a limited basis, just on like why they, their rationale for the fee, and not necessarily that person's testimony as an expert. So if they're leaning on that person as their main evidence, and that evidence isn't allowed in court, well, they have no evidence to show why they're charging what they're charging. All right. So reading through the court ruling more, the court asked why the city didn't actually provide additional evidence about why they were charging what they're charging, like the examples I just gave you. They said, well, if you're adding it to the streets fund, why aren't you demonstrating how much it costs to dig up the streets every once in a while, to replace water mains for water service, right? Or why aren't you showing how much damage trash trucks do to the streets? For whatever reason, they didn't present that as evidence. So, with the city not providing evidence to justify their complex formula that the judge referred to it as complex and not very easily understood by the layperson, it's almost like default they're going to rule in favor of the petitioner because there was no evidence by the defendant or the city to show this is why we're doing what we're doing. And the thing is, one thing I learned from Aaron Starr and Alicia Purcell, I want to give full credit to them on this. They taught me what without prejudice means. So the judge ruled again and again and again in the number of rulings at the end of the document, you'll see without prejudice, meaning it's not done. They can come back and remedy what they said. So it wasn't made, they didn't declare that what they were doing was illegal. What the judge declared was that you can do the fee, but you need to show your work. Remember when you were in school and in math and your teacher would say, great, you got the answer, you need to show your work? Or was that just me? I would just put the answer and not want to actually put out how I did all the work. So it says again and again in the ruling, this ruling is done without prejudice unless the city, if the city comes back and says, this is how we came to this formula, this is how we determine how much the fee should be, then they should be able to continue it, right? Or they can calculate a whole new fee and justify A, B, C, X, Y, Z in clear-cut terms. This is why we're charging what we're charging. So in the meantime, the ruling says the city must stop charging the fee unless they show their work. They can't transfer any more of the fees that they had to the to the streets fund unless they show their work. And then also that they have to make sure that when they do this again, that all this is done done clearly, because there was some criticism around the complexity of the formula. And again, I haven't seen the formula, but it was referred to as so many a proportion of so many employees in wastewater versus the employees in the whole city, and a lot of really odd ways to look at it. So anyways, so there's that. There were some rulings that were against the petitioner. Mr. Starr, one about vehicle code. I think from what I understood from the way the ruling read, he was alleging that the city charging a fee and then sending that fee to the streets was in violation of vehicle code in the state of California that says that a city can't charge its residents fees to use the streets. And my guess is that they're allowed to use the streets whether they charge the fee or not, or paid the fee or not. But either way, that was not granted. Also, they had passed an ordinance allowing them to transfer the fees each month to other areas of the budget, and that was denied also. It says that they did that the right way, so the court doesn't have the power to rescind an ordinance that's been duly passed by the city council. So that's kind of the gist of it. What I want to point out is that in reading it, I really went into it with a really objective mind. I wanted to see, what does this say? It doesn't matter who the petitioner is or who the defendant is, what's going on here. And based on what I saw from the ruling, the judge didn't feel that the defendant brought enough evidence or sufficient evidence to prove their case or defend their case. And in that case, they said, well, I have to rule in favor of the petitioner. So that's kind of what I read from it. As I mentioned, I will post the link for you so you can have access to the actual court ruling. I did highlights to try and help folks out. I hope that they're helpful to you. There are some areas where like every sentence of the paragraph is highlighted, but that was important information to have. And you'll see as you go through it, it gets kind of repetitive too. But I hope that that's helpful for everybody. And the idea behind this too is that I was surprised because I had heard about the IUFs way back when we talked about, or when this was talked about back in like 2016, 2017. And I was really confused by them and wondering why we needed them. And this answered it a little bit. But to me, it's just, I'm hoping that it can get straightened out because where we are now, the judge did rule that the $34 million that had been charged since fiscal year 2014-15 up until now, $34 million has to be paid back to those funds. Let's keep that in mind too. This is not a refund coming back to us taxpayers. That was not the ruling, and it's made clear in the ruling. Those are going back to those funds, all right? So those fees will go back to the funds, and then the city can still say, like, okay, let's go back to the drawing board. Let's recalculate this. Let's figure out a way that's clear-cut that shows how the fees are being charged, what they're being charged for, and then we can put them back, right? The other thing, too, is that only up until 2017 was it charged to or transferred to the general fund. As I found out later that they stopped that in 2017. And since 2017 up until today, to this very day, it's been going to the street maintenance fund. And so that seems really clear-cut to me. I can see how wear and tear happens on our streets from providing these three services. But it's up to the city to prove that, not me. So I'm hoping that they'll be able to figure that out and do that because $34 million from the general fund or from the street maintenance fund, like, where's that going to come from? Like, we don't have that. Like, that's huge. So it's interesting to me too because, like, I'll just say Measure N, N as in Nancy, which passed back in November. That was meant to fix the streets. That was the idea behind it. But, like, we're now taking money out of the streets fund to, like, that we wanted to, like, the idea was to fix streets, but we're taking more money away from streets. It's just, I don't get it, but whatever, that's just for me. Okay, I got some comments here. Let me address them. So, Alidette, basically, if I take $20 from my grocery budget to pay for gas, the next week I have to take $20 of my grocery budget to pay for, oh, sorry, I lost it. Okay, the next week, I have to do it again, take $20 more out of my grocery budget for gas, and I have to show receipts, basically. So, and then she says, Starr didn't find millions, he just needed to fix the accounting, and he wants to see the receipts. Show me the receipts. That's all you need to say, Aaron. Just go to the city, like, show me receipts. Show your work, right? All right. It's sort of a referendum to the proportion of funds allocated from the IUF. Thanks for clarifications. It's going to be good once I go over the articles. Well said, sir. Thank you for the nice words. I appreciate that. $34 million. That's too much. I don't know if you've ever seen The Price is Right, but I love that game. That's too much. That's too much, Bob. All right. Steve Nash always has really great ways of breaking this down. So Steve says, let's say the wastewater treatment facility has an accident that damages their liquid chlorine facility. Oh, I see where you're going with this. Now, the fire department has to have the expertise and equipment to deal with this potentially... Sorry, I lost my place here. Now, the fire department has to have the expertise to deal with this potentially deadly incident that would affect not only the plant personnel, but also potentially all of South Oxnard. We may never need the fire department to respond to such an occurrence, but you damn sure want to have that expertise in-house. Who should pay to have our firefighters trained in equipment to deal with this? Great points, Steve. So I think that's a lot better example than the one I gave. So the idea behind all of this, though, is that these fees were not found to be illegal. In fact, the ruling made it clear that they're allowed to do it. They just aren't showing their work on how they're doing it, and they didn't show in court how they were doing it, which that's game time. That's when you need to do it, right? So hopefully they can go back and figure out what the next move is, because we can't just lose $34 million and cut our losses and call it a day. Like, where's that going to come from? In your budget, if all of a sudden you had a judgment against you for $34,000, where are you going to get that? Where is the average person gonna get $34,000 for our city? $34 million. I mean, 34,000. Somebody can find it, but it's gonna hurt, right? For our city, same thing. I mean, we can figure it out, but we're gonna be hurting from it. I saw something that Aaron had said in a comment that actually I agree with. That it's unfortunate that it had to go to court and this had to be the outcome. I agree. I wish that the city had done their math or really put their ducks in a row way back in 2012. Keep in mind, this dates back to 2012. The lawsuit came forward in 2017, but this is a practice that has been ongoing for the last 8 years. And if you don't show your work way back then, at some point, that if you get called to the carpet and you can't show your receipts, what are you going to do, right? So that's where we are right now. We are still answering for issues that came up way back when. But you know what? Like, nothing's impossible. We'll have to get it figured out. And the way the ruling went, it was all without prejudice, and the city's going to have to figure that out now. What are they going to do to move forward, right? So, all right, that's all my notes that I got. I appreciate you all jumping on. I really spent a lot of time reading it and trying to understand everything that was going on. So I hope by me doing that and sharing it with all of you that it'll help you get a really good look at what this is all about as well. As I mentioned before I sign off, I will post in the comments a link to the judge's court ruling. I have highlighted all of what I think were the high points of things for you to keep in mind, but it's all there. You can read it as in-depth as you want. And then there's also comments that you can click on and see definitions for legal terms or what was referenced when they said something or reference case law or whatever. All right? So thank you all very much. I'm going to say Miss G is looking at using this case as an example of looking at over the books for ASB. Great. I'm glad I can help out the education system too. All right. Thank you, everybody. Hope you all have a great rest of your day, a great new year. You know what? 2020 has been tough, but if you're hearing me now and you woke up this morning, as did I, hey, you know what? Doesn't matter how bad the year is. I'm alive to say it was a bad year, but I hope that for the best for a really prosperous and much better 2021. All right. Thank you all very much. Hope you have a great rest of your afternoon. Happy New Year to you. Be safe. Be well. Take care.